What's up, everybody? It's Chris Kunz with the Rich Casino Real Estate Group. On today's episode of Real Estate Simplified, I am joined by Colin Smith with the law offices of Colin T. Smith. Specializes in everything from estate planning, business formation, conservatorships, probates, wills, trusts, all that great stuff. Colin, thank you very much for joining me, man.
My pleasure, Chris.
So we can just get right into it. Talk to me about the sort of benefits of having a property as opposed to owning it just as an individual, as opposed to Chris Kunz owning a property, to the Chris Kunz Living Trust.
So a living trust are used, generally speaking, to avoid probate in the state of California. So probate being layman's terms, the court proceeding to administer an estate when somebody passes away. So the triggers for probate in California, which this applies to all of us in California, if you own real estate or you have assets over $166,250,
okay.
That's a random number,
yeah.
But those two triggers, so real estate or assets over, we'll just call it $166,000, your estate would go through probate if you did not have a living trust.
Okay, when we're talking about probate, the reason that you want to avoid that process is because of the costs and the time, correct?
Probate is, very expensive, very time consuming, and public record. So Sacramento County is actually one of the worst counties as far as court impaction.
Okay.
So probate in Sacramento County, everything going smooth and simple, is probably going to be about a year and a half. The fees for probate are set by law. So the attorney doesn't decide what the fee is. The judge doesn't decide what the fee is. The fee for a probate is set by California statute. So the way it's calculated, I'll give it to you. It's not complex, but it's complex to hear. It's 4% of the first 100,000 in value,
okay.
3% of the next 100,000, 2% of the next 800, and then 1% over $1 million. Okay. So again, knowing those triggers for probate are real estate or assets over $166,000. If you had a house valued at $500,000, your probate fees are $43222. That's $13,000. That's times 2. So the attorney's fees are $13,000, and your executor fees are $13,000.
Oh, geez.
So call that $26,000 in probate fees, not including $2,000 or $3,000 in court costs, appraisal fees.
So, and that's just to get the property to the descendants.
Correct. So that is simply transferring title from mom to mom's 2 kids. You're looking at roughly $30,000.
If she doesn't have a trust in place.
You got it.
If I write a will, am I still able to kind of avoid that probate process?
So the problem is a will does not avoid probate if you meet one of those 2 triggers.
Okay.
So we're looking at what people have in place as far as their planning. If you have nothing in place, California law is going to decide who's in charge, and they're going to decide who inherits.
Okay.
All right? If you have a will, what you've done is you've made those wishes known in writing. So you've decided who you want to be in charge of your estate, and you've decided who you want to inherit. But a will does not avoid probate. So what I tell people when I'm giving a seminar or presentation, if you're going to remember anything, remember that a will does not avoid probate if you meet one of those 2 triggers.
So even if you say, I want this stuff to go here, this to go there, you still have to pay that. We were talking about the close to $30,000 in fees just to get your assets to your descendants.
Correct. So that's why people set up a living trust in conjunction with their will as part of their estate planning. So by transferring title of that property from Mary Jones to the Mary Jones Trust at the Sacramento County Recorder's Office, they completely avoid that probate process. The kids are able to inherit right away. With a death certificate, they're able to list that property for sale right away.
Okay. Now, should first-time home buyers be putting properties into trusts?
Generally speaking, I tell people if you own real estate or you have little kids, you probably should have a living trust. Okay, the living trust for the property, we just talked about that as far as protecting it from probate.
Sure.
Now the little kids, different issue. So even if you don't own real estate, I think you should have a living trust if you have little kids. Because if you have little kids, you probably have life insurance, or you need it if you don't have it. Say you have your 401k or your IRA and you have money in the bank. If you were to pass away, the court is going to monitor that minor's money until they turn 18.
Oh.
So whoever the guardian is of the estate, who would have to be appointed by the judge, would have to account for those funds until the minor turns 18, and then when they turn 18, they get all the money.
Oh, geez. Okay.
So you have a senior in high school inheriting a ton of money.
Great. Well, and you can actually delay that, right? Where it's like they don't necessarily get all that money at 18. You can space it out a little bit. 25,
Absolutely,
35, whatever.
absolutely. So with a living trust, you can dictate any contingencies you want in the document. You can say, okay, I want everything held until they turn 30, or I want them to receive an allowance of $2,500 a month until the trust runs out. I have people put all sorts of crazy stuff in the trust. I had one person that put in there that the kids had to be fluent in Chinese before they could inherit. So,
jeez,
yeah,
that's pretty strict.
Yeah,
I don't think that I'd get my money out of that.
You have to start now.
Exactly.
Yeah.
Talk to me about the sort of costs that are associated with putting a property into a trust.
So when I set up an estate plan, when I reference estate plan, I talk about all the documents that would go into an estate plan, which generally is your healthcare directive and your power of attorney, your will, and your living trust. The healthcare directive and the power of attorney, those are the documents that control in the event of your incapacity. So if you were in a car accident or a coma, you had COVID, heaven forbid, these are the people you trust to make medical and financial decisions. Now, when you die, those documents die with you, and then we go to your will and to your trust. So to get all of those documents prepared, which I consider a full estate plan, you're generally talking in the $2,000 to $3,000 range, depending on the complexity of the estate.
Which pales in comparison to the $30,000 that you're going to be paying if the property goes through probate.
You got it. And I didn't mention it either, but probate is public record, meaning that somebody could go pull a probate file and see all of the assets of the estate, who you owe money to. People are able to make claims against the estate, if you owe money, etc.
Oh, and so when I see properties that are listed for probate on the MLS, that's the sort of thing that you're talking about, because when you purchase a property through probate, if the court still needs to confirm that sale, there's a potential for you to actually get outbid at the court date by investors or whoever might still be interested in the property, right?
Yeah, so there's different situations based on the circumstances of that probate. So depending on the situation, the executor or the administrator, and again, that's the person in charge of the probate, they may not have to get court approval at all. Okay? Sometimes they'll have to notify the heirs. So they'll have to send a notice to the heirs telling them that they're going to sell the property. The heirs can then object to that sale if they want to. And then the situation you're talking about, sometimes the court actually does have to approve the hearing. And in that situation, the executor or the administrator has to publish the notice in public record in the newspaper, set a court hearing, and that's where you have a situation where people show up at court and can outbid whoever that original person is on contract.
Gotcha. What sort of situations would a probate sale not require court confirmation?
Great question. It would not require court confirmation if, let's say, all the kids get along. Okay. So let's say one of the kids is the executor, and the two of them say, okay, well, we love and trust you, so we're going to sign a waiver saying that you can do whatever you need to do to deal with estate property. Those waivers are then filed with the court, and now whoever the executor is can go sell the property just like a normal transaction, 30-day close, without notifying the court, without notifying the heirs.
Makes it way easier. Gotcha.
You got it. Yep.
Okay.
Yep.
Talk to me a little bit about the difference between putting a property in a trust and putting it in an LLC, because I hear about people doing both kinds of deals. What are the advantages and disadvantages of kind of doing that?
So your primary residence, you're going to want in your living trust. Okay. Your primary residence because of capital gains. So as of now, capital gains taxes, your first $250,000 is excluded for a single person. Okay. First $500,000 for a married couple. You don't get that if it's owned by an entity. So your primary residence is going to be in your living trust. Investment properties, commercial properties, rental properties, apartment complexes, that's where you want to have those properties in an LLC. Now, there's no tax benefit generally to have those properties in LLC. What you have is your liability protection. So that LLC limits the liability to that asset that is in the LLC. So you're still going to have your general insurance. I recommend all my clients have umbrella insurance as well. That LLC, what I tell kind of my clients is, how well do you want to sleep at night? If you really want to sleep soundly, you'll do the LLC. Because there is the expense of setting up the LLC, there's the potential CPA costs going forward every year.
Right, 'cause you have to manage it.
Filing tax returns for an LLC. There's filings every other year with the Secretary of State. Nothing complex, but yeah, there are going to be fees associated with that LLC.
Typical cost for setting up an LLC?
You're going to be probably less than $2,000.
That's not bad.
Yep, less than $2,000 to do everything, and that's just your initial setup cost, and then going forward, whatever your CPA is going to charge. Your attorney really probably isn't going to be involved too much going forward with the LLC.
Just setting it up, right?
In getting the property funded, meaning the deed transferred into the LLC at the county recorder's office.
Got it. Okay. So when we're talking about placing a property into a trust or setting up an LLC, how long would you say that process typically takes? So if I sat down with you today, Colin T. Smith, and I wanted to put a property into a trust, how long would it take for us to do that?
I tell people generally it's as fast as you want to do it. You could walk into, I could prepare a deed in 20 minutes while you're sitting here, pull the title to your property, prepare the deed. You could drive over to the recorder's office right now.
Oh, geez, okay.
But to set up a full estate plan at my office, I generally am lag time at 3 to 4 weeks out.
Okay.
But yeah, setting up, getting the property transferred into the trust is simply just preparing the deed and getting it recorded at the county. The county records upon presentation.
Okay. Now, is that something that you would recommend people do during the escrow process, or close escrow, get the keys, then call you?
So that's a great question. It's a tough one because escrow is generally going to want to deal with the people. They don't want to bring in the complexity of the living trust, which is annoying because if you have a living trust already in place and you're going to buy a property and you say, here's my trust, sometimes they're going to say, oh no, we can't do it, or we need this, that, and the other.
Attorneys always complicate things.
Yeah, so whether you do it before or after, just make sure it gets done.
Sure.
What I see often is refinances. What the refi will do, they'll pull the property out of the trust to secure the loan because they want a loan to individuals.
Oh, okay.
And then they don't put the property back in the trust. So the client thinks that it's in the trust, but that mortgage company or the title company didn't put it back in the trust. So I'll have clients come in that had refied 5 years ago. They think the property's in the trust and it's not, and that's a big mistake, big error.
So the client, the borrower, is supposed to be the one to monitor that. So if you get a refinance, make sure that property gets placed back in the living trust.
Yeah,
right?
I've had clients pass away in that situation where they have a trust, but the property was not in the trust due to a refinance.
Jeez, that's tough. Okay. And just to sort of wrap up here, so how long have you been doing that? How long have you been in Sacramento, and kind of what services? Give me the full scope. Give me the elevator pitch for the law offices of Colin T. Smith.
Well, I'm a full service estate planning law firm. What I tell people is when you call, don't be surprised when I answer the phone because I'm the one who answers the phone. So you're going to get me. Clients generally like that. Attorneys get a bad rap for not being accessible.
Sure.
I try to make myself as accessible as possible. So been doing everything estate planning for almost 15 years now. Grew up in the greater Sacramento area, so it's good to be here. Right here on University Avenue, close to East Sac, right in the heart of Sacramento.
Yeah, and if there's anything else that you guys need, I'll put all of Colin's information down at the bottom here. Give him a call for estate planning, trust, wills, conservatorships, business formation. Anything else that I missed in there?
You got it. No, that's it. Yeah.
Well, thank you very much for joining me, Colin. I appreciate it. Thank you guys for joining us on today's video. If you have any questions, real estate or estate planning related, give me or Colin a call. Reach out to us. We'd love to help out. Otherwise, we'll see everybody soon. Stay safe out there and take care.